The topic is sum coverage. The speaker is Brendan Baines.
How many of you out there have some coverage? How many of you know what your limits are? How many of you have been to a seminar like this before? It is the cheapest coverage out there for you with the most benefit. And before I get into the substance of sum, I'll beat the horse, beat the drum, buy some, make sure it matches your liability limits. If it's 300, 500, whatever it might be, it's great coverage and it's cheap. And it protects you against the wrongdoer who's rolling around with a $25,000 policy. So, what is sum? We also have as a topic. I have very little time, so I'm not going to be able to get through all of it. But sum is supplemental underinsurance motorist coverage. It is optional, hence you have to buy it. Coverage is mandatory, $25.50, just like a mandatory policy. But sum is optional. And it's often misunderstood and often missed in litigation because people don't always look to the various sources for sum coverage. There's some fundamental touchstones for sum that I will mention now and then work through and hopefully get through all of it in 10 minutes, which is going to be a tough job. Notice. Trigger. You've got to trigger a policy. Tender. You've got to exhaust the underlying tortfeasor's policy and tender that to the insurance company to potentially get some. Litigate. You got to arbitrate or litigate that sum claim to get the benefit. There's some sub-components to that, but then you've got the great equalizer, and that is offset. You keep those 5 things in mind, and you'll have a pretty good grasp of sum, if nothing else. So let me backtrack to notice. Mackenzie talked about putting a carrier on notice. Unfortunately, for whatever reason, some carriers do not get put on notice by plaintiffs' attorneys or by plaintiffs themselves within a short time frame of the accident happening. You should make it a practice to put your sum carrier, if you've got a client come in and they've got some coverage, put the carrier on notice, even if they have a hangnail. I mean, if I'll put it this way, if you sign them up, if you have a retainer, serve the sum note, put a notice to the sum carrier of the accident. That's all that's required to preserve your rights. Notice of the accident and that there's a potential sum carrier down the road, some claim down the road. It's not notice of catastrophic injuries. It's not notice that your claim is worth X number of dollars and that it's in excess of what the underlying policy is of the tortfeasor. So get that notice out. It's a cheap letter. Get it out there and get it out there quickly. Because the case law of the state of New York is that if the carrier has notice, they have to prove prejudice. If they have notice of the accident, they have to prove prejudice of any later claim. In other words, you could give notice in that first letter and then not actually make the claim until you're at trial. You sort of forgot about the issue, whatever the case might be. But if they have notice of the accident from you or through the no-fault process or an accident report, even a property damage claim, if they have notice of the accident, they've got to prove prejudice. And that's the Reckemeyer case, which is 2005 Court of Appeals case. It's at page 40 of the materials. That was preceded by Brandon versus Nationwide, which was all the sum policies have a policy requirement that you have to serve notice of suit papers. That's a notice that follows the notice of the accident. Notice of the suit papers. So when you bring suit, send it to the sum carrier. Brandon versus Nationwide broke away from the 3420 case law at the time, which was no prejudice rule for New York. And for this sum policy, the Court of Appeals in Brandon said, you know what? Notice of the suit papers, that's not so important if you knew about the accident. Carriers, you got to show prejudice. So that was sort of the erosion of the no prejudice rule in New York. And then it was fortified by Reckemeyer in 2005. And then last year it became the law of New York for all claims, just not only some. But who do you give notice to? The coverage ticklers, if you will, are on page 43. Obviously, the named insured, he owns a policy. Some, you serve the notice. If you are a resident relative of a person that has, and you live in a residence and you're a relative of someone who has some coverage, you get some coverage through their policy. You got to prove that you're a resident by blood, a relative by blood, and that you reside in that house, and that's where the fight usually is. But there's another source for some there. If the vehicle in which you're a passenger of is operated by an owner who has, or an operator who has some coverage, you put them on notice too. There's another source for coverage.
Can I just
Sure.
said something I just wanted to think about, and I don't want you to take away. I had a case once, and Brendan mentioned resident relative, and especially in the sum situation. And I've had a case once where the couple had a child, okay, or I forget if it was actually through marriage. The couple was not married, okay, but that's what it was. They weren't married, but one of them had a child. The insured driver, it was not his son, it was his girlfriend's son who lived in the house. So they had to be careful because it almost sounded like a resident relative. And it went into litigation, and the claims professional didn't pick it up, and they provided the defense and the coverage, and it realized afterwards they were never a resident relative. Okay, it was never a relative, technically, and it had a situation where they were not married and a child. So it's just something to think about, and I've seen before.
Now, what kind of prejudice might the insurance company show to defeat the coverage? Spoliation. Spoliation of evidence. Maybe a waiver of subrogation, their subrogation rights. Under some, the carrier who pays out some has the right of subrogation, not affected by this new GOL provision. So those are the kind of things the carrier is going to show prejudice, might knock out your coverage. What's the trigger? Well, you look at the policy of your claimant. You can look at the policy of the defendant or the tortfeasor. Get the deck pages, and a lot of people would say just compare the deck pages, and you're done. If the claimant's got 100 and the tortfeasor's got 25, you've hit the trigger right there. That's pretty simple. But when you get 100 and 100, say 300 and 300, because that's what a lot of the case law fit around those numbers, it's not the deck page. It's not the limits. It's the available limits. So if you've got a combined single limit policy where the defendant has paid out $7,500 on the property damage, all of a sudden they don't have 300 available limits, and you've met your trigger. Or say you got a 300 policy plus property damage, and the claimant has that's what the claimant has, and the defendant has 300 combined single limit, including property damage. Because the property damage is extra coverage, you've met the trigger. That was the Zelli case.